We'll call People versus Austin Wright, 25 CR 1212. I'll take appearances. Ms. Raines.
Morning, Your Honor. Katie Raines on behalf of the people.
Thank you. And sir, if you'd say your full name, please.
I am the living, breathing man, Austin James Wright, Jr.
Mr. Wright, I will consider that you have entered your appearance. I will say that I acknowledge your non-conventional entry each time requested. I don't know if that's an attempt to lodge an attempt at a sovereign citizen entry to suggest that the court does not have jurisdiction over you. I will simply let you know if at any time I'm not aware of whether or not Austin Wright is present, I will have to issue a warrant for his arrest. I acknowledge your appearance, Mr. Wright. You have entered that appearance. There is no need for such a warrant this morning. Good morning to you and Ms. Raines. We're set for motions, and the reason the court set this motions, and it was an additional motion setting because the court wanted to make very clear to Mr. Wright that we were set for this motions and that the court wanted to clarify any motions filing deadline and the court's deadline for any plea cutoff. I acknowledge Mr. Wright's previous filing as it relates Mr. Wright, you filed a motion on August 4, 2025, and the court previously ruled on that. I acknowledge it just once again because the court recognizes that there have not been additional filings since then. The court recognizes the motion is based on a concept of corpus delicti. The court's already ruled, and Ms. Raines, let me look to you and ask you just to bring me up to speed on status, and I'll give Mr. Wright the same opportunity.
Yes, Your Honor. An offer has been extended. I can make a lawful record. My understanding is that Mr. Wright does not wish to accept the plea offer and wishes to have a jury trial.
Mr. Wright, is that your understanding? Is that what you don't want to accept the offer and you want to go to trial? It is your right. I'm just making sure to clarify.
Well, there's a bunch of things that I have questions about.
Welcome back, everyone. Today's case is one of those courtroom encounters where the outcome may ultimately depend less on the evidence and more on the defendant's willingness to understand the legal reality sitting right in front of him. We have Austin Wright, a man facing 8 separate charges, including to felonies, standing before a judge who is making every effort to explain the process, preserve the record, and ensure there are no misunderstandings later on. But as you'll soon see, Mr. Wright appears far more interested in challenging the court's authority than addressing the allegations themselves. What's fascinating about this hearing is that it isn't even the trial. This is simply the pre-trial stage, where the court is handling motions, discussing procedures, and making sure everyone understands the options available. Yet, despite that, we're already seeing many of the arguments commonly associated with sovereign citizen ideology, questions about jurisdiction, demands for injured parties, concerns about financial interests, and refusals to recognize the authority of the court. But here's the real twist. According to the prosecution, Mr. Wright has been offered a plea deal that would significantly reduce his legal exposure. Instead of risking convictions on multiple charges, including felonies, he has an opportunity to resolve the matter with substantially lower consequences. The judge wants to make absolutely sure that if Mr. Wright rejects that offer, he does so knowingly and voluntarily. As you watch, pay attention to how patient the judge remains throughout the proceedings. Notice how often the court gives Mr. Wright opportunities to ask questions, file motions, and seek legal counsel. Then ask yourself this. When someone chooses to represent themselves while rejecting legal advice and plea negotiations, are they exercising independence or simply creating bigger problems for themselves?
Are those questions that you think you might wish to ask a lawyer? All right. Are there just personal questions that you are contemplating in your mind, or the questions you wish to ask Ms. Raines or the court?
Questions I'd like to ask her
All right.
on the record.
Well, I can't be part of your negotiations with.
It's not a negotiation.
Help me understand, for example, what
I'm
you're.
just trying to-
Mr. Wright, hold on. We're going to talk one at a time. And so help me understand the nature of the questions you'd like to ask Ms. Raines.
The nature and cause of this action.
Mr. Wright, have you received the discovery in this case? Those are the police reports.
Some of them I still have. I was called yesterday that there's more discovery that I have to pick up
All right.
today.
Ms. Raines, any record on Mr. Wright's obtaining the discovery in this case?
I actually don't have a note from our discovery department about whether he did pick up the initial batch. I can tell the court there are, I think, 2 new documents. One is a CV for a crime scene analyst who fired a weapon, and another is a criminal history for the traffic victim in the case. The rest of the reports should have been available to him, and so if he did pick up initial discovery, he should have all of those initial police reports.
All right. So, Mr. Wright, I'll let you speak with Ms. Raines. I'm not going to facilitate a discussion. I've given you an opportunity to file motions for me to entertain today. What I'm going.
I filed a motion, sir, and you set a hearing for it, and it was never heard, and you denied it. So I understand that I don't get a fair hearing here in this court.
Right away, we're seeing one of the biggest challenges self-represented defendants often face. The court is attempting to discuss procedural matters, deadlines, and the status of the case, while Mr. Wright appears focused on broader philosophical objections rather than specific legal arguments. Courts generally operate on statutes, rules of evidence, and established procedure. They don't typically stop proceedings to debate theories about jurisdiction unless there's a legitimate legal basis supported by law and precedent. What's important here is that the judge isn't shutting Mr. Wright down completely. In fact, he's giving him multiple opportunities to explain himself, file motions, and present concerns through the proper channels. That's a crucial distinction. Many people watching these cases assume that simply raising an objection automatically requires a hearing or a ruling in their favor. In reality, courts evaluate whether the objection has legal merit before dedicating time and resources to it. The question for viewers is this: if you were facing serious criminal charges, would you spend your limited courtroom time discussing the evidence and your defense? Or would you focus on challenging the legitimacy of the process itself?
And I also would like to know the financial interest of all the parties in this room to the outcome or the process in this courtroom.
Mr. Wright, your motion that you filed implicating corpus delicti, which I read to be pertaining to your challenge of facts and circumstances constituting an alleged breach of law, I recognize that the matter was bound over from county court to district court on June 18, 2025. In light of the charges, I don't see that you had an opportunity for a preliminary hearing. The court does not have to go through a probable cause determination other than what's afforded by law. And when there's an opportunity for a preliminary hearing, your motion I read to be one in which there is challenge of probable cause. I previously denied that request based on your plea of not guilty, your challenge that there's insufficient law.
Look, I didn't plead not guilty.
Mr. Wright,
You entered that plea for me
Mr. Wright, you're interrupting me, sir.
from the bench.
Mr. Wright, you interrupted me, and I'm going to finish talking. First of all, you asked me why I had not given you a hearing on that motion. That motion I ruled on. I don't find anything further that requires a presentation of evidence or further hearing. I gave you until November 12 to file any additional motions. None were filed. Today, we're set for that motions hearing. Mr. Wright, I've given you that opportunity. As far as your not guilty plea, I'm not going to cause delay waiting on you to enter yourself a plea of not guilty. So I entered it on your behalf, which is the option preserving your constitutional rights if you do not enter a plea of guilty. So that's why I've done that.
Attention to anybody's constitutional rights, and you don't try the law and you don't try the facts.